Winn-Dixie. This is an appeal from a $3.6 million verdict for a slip and fall at Winn-Dixie, where the plaintiff injured her knee, had 7 subsequent knee surgeries, unfortunately, most of them arthroscopic, had a knee replacement, unfortunately was allergic to the material and ended up with a second knee replacement. The issues on appeal, however, are that this verdict is excessive in spite of, or even considering, the 7 surgeries, and it was due to 2 main reasons. The first was that the court, over repeated objections from the beginning of trial to the end, allowed the duty to warn theory to go to the jury, as opposed to simply whether the premises were maintained in a reasonably safe condition. And the case law in Florida, it gets kind of murky when you're looking at how you apply those 2 things. Because the law is where an invitee's knowledge of a dangerous condition will adequately protect him from harm, an owner's duty with regard to the condition is limited to giving proper warning. Now, a lot of times what happens is when there is a duty to warn, the plaintiffs come back and say, oh, but your premises were dangerous. And so automatically that gets to go to the jury. That's not exactly how that works. In this case, we have an ordinary routine cleaning of a bathroom and something that's expected, and we would hope that they would do this. So we're not talking about some unusual situation that would exist in a grocery store at any point in time. The floor was being deep cleaned by our employee, Lisa Wagner, who was over by the sinks when the plaintiff's daughter, the plaintiff and her daughter...
Can I ask you a question? Is part of your argument dealing with comparative negligence?
I'm sorry?
Is part of your argument dealing with comparative negligence?
Yes.
And then how do you explain there being no percentages of fault attributed by the jury in paragraph 3?
Well, that is part of our argument. Part of our argument is that the prejudice from A, allowing the duty to warn to be argued in the plaintiff's count of negligence, along with...
was returned?
Well, with the prejudice from this evidence regarding Lisa Wagner and her epilepsy condition, all of this combined to inflame the jury and mislead them. And so they were more intent on doing exactly what the plaintiff was arguing in closing, should be punishing Winn-Dixie, because not only did we not take care of the plaintiff, but we didn't take care of our own employee who had epilepsy.
So try to get to my question. What happened in the courtroom when the verdict comes back and you look at paragraph 3 and all the percentages of fault are blank? Is it blank in my form only and written in everybody else?
Oh, are you asking whether there was an immediate objection to the verdict form?
Yes.
No, there was not.
So nothing happened?
No, there was not. And I'm not sure oh, that's an interesting question. And I've been doing this a long time. I'm not sure that you have to object to the percentages of fault at the time.
Well, they're blank. The only reason because it seems like you're arguing comparative negligence. That was their fault. But it doesn't show any percentage being on the verdict form. So that was my question. You're saying there was no objection. Oh,
then I may just have been completely wrong about that.
That's okay. Move on. I don't want to derail you.
I understand that. The point is that it's not every time you have a dangerous condition that you have a duty to warn. If the dangerous condition is open and obvious, and it's something that you haven't had a chance to correct because, in fact, the dangerous condition is you're cleaning something, and you're not going to be able to correct that until the cleaning is finished. What the case law says is that your duty to warn is sufficient. And in this case, there wasn't any question about the warnings because Mrs. Smith and her daughter go to the Winn-Dixie to buy a birthday card. They're looking at birthday cards. The little girl has to go to the bathroom right away. And so her mother says, go ahead and go. She runs to go to the bathroom. The mother puts the birthday cards back, and she follows her into the bathroom. The bathroom is being cleaned, and the attendant, Lisa Wagner, allows the child, because she's not going to tell a little kid, no, you can't come in here, allows the child to go to the bathroom. And as she's going to the bathroom, Mrs. Smith opens the door to the bathroom, which she said it was not locked, it was closed and you could go in, opens the door, takes one step into the bathroom, and sees that the bathroom floor is wet and soapy. her child exits the bathroom, goes and washes her hands, comes back, and during this time, she has a conversation with Lisa Wagner, who she said is standing over by the sinks, pouring soap on the floor, crying. And she tells Lisa, you shouldn't be adding soap to the floor, it's already wet and soapy. And so Lisa says to her several times, please be careful. Also tells Samantha, please be careful, the floor is wet and slippery. No question these warnings were given. No questioning that even without the warnings, Mrs. Smith is completely aware of the condition. And in fact, as she opens the door to hold it for Samantha to go underneath, she tells Samantha, be careful going out when you step. Samantha goes out, no problem. Mrs. Smith goes out, doesn't even go out, takes one step and slips and falls and injures her knee. So our position is that because there was no question, the warnings were given, and this is a situation where we would not be correcting or be able to correct the dangerous condition until the cleaning was finished, that the jury should have only been allowed at most to rule on whether we failed to maintain our premises, but in fact, really under the law, once the plaintiff is aware of the dangerous condition, again, not hidden, not anything else, open and obvious, that once we have warned that plaintiff, our duty ended and we owed nothing else to the plaintiff to do. We had no other obligation. And that was the argument that was made at trial, not only as to our directed verdict on the duty to warn, but also in objections to the jury instructions. I do know the plaintiff has stated that we didn't object during the charge conference, when I think when you read the transcript, first of all, it's clear we objected to the jury instruction pre-trial and all the way through trial, and objected right before the charge conference. So our position is, had we just reiterated it for the 10th time, probably by that point in the trial, that would have been, you know, it would have been a waste of time. The judge repeatedly denied it, just like with the duty to warn, denied. So I don't think there was any waiver on that issue. And so we think it was properly preserved, and that should not have gone to the jury. That perhaps standing alone, and again, I understand the difficulties and the technicalities regarding the landowner's duty, and when you should warn, and is warning enough, and when you should be free from liability. I think in this case, the overlay with the evidence regarding Lisa Wagner's epileptic condition is the thing that, if anything, really tipped the balance here. Pre-trial, again, pre-trial, throughout trial, we objected to the testimony that our employee suffered from epilepsy. What happened in this case is when they took the deposition of Lisa Wagner, the plaintiff asked Lisa, were you concerned, uncomfortable, or afraid when you were cleaning the bathroom? And she said, yes, because I have epilepsy, and I was concerned that if I'm deep cleaning the bathroom by myself, I might have a seizure and nobody would find me. Now, A, none of that's got anything to do with the actual cleaning of the floor. B, more importantly, Lisa then testifies she never told Winn-Dixie of this concern. No dispute. She had never had a seizure before, never had a seizure afterwards. And so the plaintiff argues, well, this is relevant because she was hurrying. No evidence was ever presented that she was hurrying while she was cleaning. And so the judge twice, when he considers it by the time of trial, because we moved in limine, of course, to exclude it, by the time we move at trial, the judge twice says, I don't see how her medical condition is relevant to your case. And the plaintiff kept saying, well, we're going to show you, and judge, once you read her deposition, you will see why it's relevant to our theory. Again, there's nothing in her deposition that says she was rushing, hurrying, nothing. What the deposition simply said was, I was afraid I would have a seizure, something Winn-Dixie knew nothing about, never occurred, was never an issue. The third time it came up at trial was after the judge had read the deposition, and this, I think, is really critical. This is why the judge let the evidence in. And this is in the transcript at page 42. The judge said, I read the deposition, and I think it's a good thing that Winn-Dixie hired somebody who suffers from epilepsy, and therefore I'm going to allow this testimony to come in. Because it's positive for Winn-Dixie. Well, we're saying, excuse us, but the jury is going to be misled, and we're going to get vilified for forcing an epileptic to clean a bathroom at Winn-Dixie. And of course, that's exactly what happened. Exactly what happened. And so we're saying that these two errors combined led to the verdict in the case, which we claim really is excessive, because it's an award of $500,000, $250,000 for past medicals, and $2,500,000 for a total of $3 million in non-economic damages. And regardless of the fact, and I, believe me, sympathize with this poor woman who they could not get her knee surgery right, and the doctor kept saying, well, I went in and I cleaned this, and then I went in and I cleaned this, and then I went in and I adjusted this. Maybe I should have done this better or more often or whatever, that there simply is no basis to uphold an award of $3 million for non-economic damages. I would like to reserve the rest of my time for rebuttal.
Okay, thank you.
Good morning, I'm John Crabtree. I represent Tanya Smith. He didn't let the evidence in because he thought it was good for Winn-Dixie. He just commented that that was a fact. He let the evidence in because it supported our theory, which we were allowed to pursue, which was that she was hurrying, and there was reasonable evidence to reach that conclusion. She was using the wrong materials. She used a special fast-acting agent. She poured the material directly on the floor rather than in the bucket. She was doing things wrong, and she admitted she was scared to be in there.
Counsel, I have a hard time understanding how cleaning the floor has anything to do with epilepsy, or epilepsy has anything to do with that. There wasn't anything in the record that says she was doing all of these things because she had epilepsy. The record is clear that she didn't have any seizures while this was going on. Explain to me where the relevance is.
Well, Judge Boyce, the reason why it's relevant is this. Our theory was that she was scared to be in there, and that is why, and it supported our part of our theory also, that's why she was doing things wrong. Like, for example, she didn't put a warning thing outside the door. She claims that she thought she did, or that was part of her sort of wishy-washy testimony. Now, if she's hurrying, she's not going to do things necessarily right. Part of the theory was whether or not she had poured the agent directly on the floor rather than the bucket. She said she thought she put it in the bucket. Ms. Smith said she poured it directly on the floor. These were disputed issues of fact, and the fact that she was scared to be in that room was relevant because it supported our theory of the case, which we were allowed to do. And this judge, this trial judge who sat there, exercised his discretion and did not just rule willy-nilly. He carefully looked at the evidence, decided what part could come in and what part couldn't, and in the exercise of his discretion, he drew the lines where he drew the lines. He didn't abuse his discretion. We were allowed to pursue our theory. Our theory, she was scared to be in the room. She said she was scared to be in the room. And our theory was that she was rushing, and the evidence supported it. She used the fast-acting agent. People ought to do that. Besides that, we're in 2013, 2014. This is not like we live in an era where people are afraid of epileptics. My grandmother used to worry that epilepsy was contagious. People don't think that way today. There's nothing bad about epilepsy per se. There was no one attacked her as a bad person for having epilepsy. None of that happened. We were just simply explaining she had a medical condition that made her afraid, and that's why she hurried, and that's supported our factual theory that she was doing a bad job.
And there was knowledge that Winn-Dixie knew about the medical condition?
Yeah, they knew about her medical condition. I mean, the fact of the matter is that, she is their employee. They're responsible for her negligence. She did the job poorly.
Are you sure there was evidence in there that Winn-Dixie knew about the epilepsy?
Yeah, they knew she had epilepsy from the day they hired her. That wasn't an issue.
I thought opposing counsel said that the deposition says there wasn't any.
Opposing counsel said a number of things that I need to correct before we're done, but I don't think she said that. No, Winn-Dixie knew when they hired her, and in fact, the comment, the exchange you referred to pre-trial between the judge and Winn-Dixie's counsel was that it would make Winn-Dixie seem like a good corporate citizen, which Winn-Dixie's counsel agreed to. That was just an aside. And I think Winn-Dixie does look like a good corporate citizen for hiring someone with epilepsy. There's no reason not to do that. There was reasons not to perhaps leave her alone in the room, or putting that even aside, she just wasn't doing a good job. And the fact her epilepsy factored into that. And this is a judge who was careful about not letting, parts in that didn't support our theory. If you read the the testimony in the trial itself, like pages like 810 to 820 or somewhere in that area, they have a whole meaningful exchange, and parts stay out and parts come in. That's what trial judges do, and that's what they're supposed to do, and that's what he did here. I want to hit a few other points if I could. The whole discussion about failure to warn is academic in this appeal because they've got a glaring two-issue rule problem. We went to the trial, went to the jury on 3 different theories. They've only appealed one of them. There's not much reason to discuss failure to warn, but I will discuss it for a moment, which is you have to keep in mind that Tanya, there was no warning sign in our theory of the case. She walks into the room. It's then that she realizes that she's got a problem. She doesn't know as much as Winn-Dixie does, which has its own protocols and makes its employees wear special shoes. Our theory of the case, Lisa Wagner was pouring greased lightning directly onto the floor. It's overly soapy, and it's a mess. That's our theory of the case. They knew more than we knew. They didn't maintain it properly. They didn't follow their own protocols, and that's how the injury occurred. On the issue of damages, we had $600,000 of medical damages. We didn't have $300,000 of medical damages. A few things. And yeah, she had $2.5 million of pain and suffering, but of course, we use pain and suffering these days often as a shorthand for all the non-economic damages people are entitled to. It's pain and suffering, loss of quality of life, and so on. In this case, we had before and after witnesses, we had 7 surgeries. She had a nickel allergy. Between her first knee replacement and her second, she had to wait many months while we waited for the FDA to approve a nickel-free prosthesis for her leg. All this was, rather horrible. The jury did its job, and the judge did as well. Comparative negligence. Judge Filani, I noticed you picked that up. I looked at the verdict form while I was sitting here, and above the apportionment question, the jury answered that she was not at fault, and that's why there was no comparative fault percentage in that question. And the reason why, our point is that...
So it would have been redundant, what you said.
Right. They didn't do that because she's a mom following her 7-year-old daughter into a bathroom. And that's one way of viewing the evidence. They could have gone the other way. They could have found her partly at fault. They didn't. That's what juries are for. So the jury didn't find her at fault, and the judge didn't find that the jury was,
I mean, it sounds like they were arguing comparative negligence, and there was no comparative negligence found.
That's correct. There wasn't comparative negligence here, and that was the jury's conclusion, straight up. I don't want to waste the court's time. If you have any last questions, I'd be delighted to answer them. Otherwise, I would just suggest the court should affirm. Thank you.
Well, I guess I'm not completely crazy. I knew there was something with the negligence of the plaintiff on the
But I mean, it sounds like you're
and that was
arguing
what they had said
comparative
was,
negligence.
was there negligence on the part of Mrs.
Yeah,
Smith? And the
said
answer
to skip
was,
that.
yeah, the answer was no.
Right.
Briefly, the 2-issue rule simply doesn't apply in this case. We've cited to the Supreme Court's decision in, I'm going to mispronounce it, Grenitz v. Tomlin, which talks about the fact that the 2-issue rule, again, something that gets used and misused and misquoted, only applies when there are more than one causes of action. And Grenitz expressly says, if you have a sole claim for negligence, the 2-issue rule simply does not apply. And that's exactly what we have here. We have an amended complaint, 1 count for negligence. The jury was instructed 1 negligence count. And so this clearly is the exception to the 2-issue rule. And in our brief, we did present case law, federal case law, and out-of-state case law, because the 2-issue rule is the minority opinion. I'm not asking you to change that. Florida has a lot of archaic things that we usually love, like the tipsy coachman rule and things like that. All I'm saying is those cases discuss why, when there's an error in the verdict as to one of the issues presented and a general verdict is used, a new trial is still required. And that was just for informative purposes, because we truly believe when you look at the real use of the 2-issue rule, if you only plead 1 cause of action for negligence, and that's your theory that goes to the jury, that is 1 theory of 1 cause of action. And the 2-issue rule simply does not apply under those circumstances. And we've given the court those cases in our reply brief for you to review. Their theory regarding the epilepsy evidence is that it showed she didn't follow the protocol. That's absolutely not true. There's no evidence she didn't follow the protocol. There's nobody that said that anything that she did when she was cleaning that bathroom was wrong. The only issue was, did Mrs. Smith and her daughter know the floor was wet and soapy? The answer is yes. So the whole issue was the floor wet and soapy, and where was the water? It was over by the sinks, it was by the handicap stall. Matter of fact, actually it wasn't at the front door where you walk in. All of that testimony was presented. So whether or not she followed protocol, that was not the proximate cause of the slip and fall. In other words, the floor was wet, the floor was soapy, because the floor is being cleaned. No evidence she deviated from protocol, especially none because she had epilepsy. She clearly testified, I have never had a seizure before while I'm cleaning. I have never had a seizure after this incident because I was cleaning. Winn-Dixie knew I had epilepsy. Winn-Dixie testified she has never had a problem with epilepsy as long as she's been our employee. Unfortunately, that was the testimony, I guess, that decided for the judge that this should come in because this is favorable to us, and that's exactly what they argue in their brief. Well, they made the best of that evidence that they could. Well, what are we supposed to do with it? Yes, we hired an epileptic employee. The very thought that this doesn't have some kind of stigma or taint to it is ridiculous, regardless of the fact that this is 2014. That's unfortunate, but we all know, I think in our common sense, that that's true. That error alone, allowing all that evidence regarding epilepsy, combined with their argument that went along with it. Look at what Winn-Dixie is doing. They refuse to accept responsibility for this accident, and they refuse to even protect their own employees. We didn't give her boots. They actually argued that in closing. Well, as it turned out, she had the right kind of sneakers on. She didn't need boots. But that's how that information was used and twisted around in order to hold Winn-Dixie liable when there was no question that the plaintiff and her daughter absolutely knew of the dangerous condition.
Counsel, tell me what the evidence, refresh my recollection of what the evidence said in regard to the boots and the sneakers. You made a statement that there was evidence that they didn't need to wear boots.
Right, one of our employees said that one of the things that they had suggested or would supply was boots, but they also would allow them to clean in heavy-duty sneakers, and that's what she was wearing. So even but they made a big deal about that, saying, well, look, our employee has to wear boots and sneakers because the floor is wet and slippery, but our plaintiff, who has wet sandals on,
that was part of protocol?
Is expected to work on the right floor.
Was there any evidence that that was part of the protocol for people cleaning bathrooms?
Yes, yes, absolutely, absolutely. And again, she complied with our protocol. But they were using as a contrast, saying, here's the innocent plaintiff in her wet sandals when they have to wear boots or sneakers when the floor is wet. Bottom line, plaintiff knew the floor was wet, knew it was slippery, she was warned, we did everything we were supposed to do as a matter of law, and we are entitled to a new trial.
All right, thank you both. Our next case up this morning